Okay, so we're going to go ahead and get started with our introductory information to give folks a chance to join in for our content. Good morning, everybody, and welcome to the Small Business Weekly webinar series session 2. Today, we're going to be focusing on legal considerations for small businesses, focusing primarily around the employment law side of the considerations you should be making and addressing some of those questions as they come in. We first want to say thank you so much to Bank of America, who is our presenting sponsor for Small Business Week 2020 in San Francisco. We've had to make a pivot from our week of events, which was originally scheduled to take place in the first week of May, but realized that we could still work hard to bring meaningful resources to our small business community. Thus, we now have our Small Business Weekly program, which is a weekly webinar series focused on topics that are pertinent and top of mind for you. So be sure to stay tuned and see what other topics we have coming up as we move throughout this series for the next several weeks. First, I would love to introduce just myself and Becca Bloom. I am Amelia Lindy. I'm our webinar host for today. I'm the Small Business Manager at the San Francisco Chamber of Commerce and also the Chair for San Francisco Small Business Week. I am going to be your host today and helping moderate this program. And then I also have Becca Bloom, who is our webinar stage manager. She is the owner and event producer for BB Events, and she is our event producer for Small Business Week in San Francisco. Up next, a little bit of housekeeping. All of the participants have been muted upon arrival and during the duration of the webinars. In order to ask questions, we ask for you to use the Q&A button at the bottom of your screen. We'll do our best to answer all of those questions that come in as best as we can. And if not, we will be doing an FAQ, compliments of Housaye Law afterwards to send to you all. I just will emphasize that there is both a Q&A function, which says Q&A at the bottom of your screen, as well as a chat function. And we really want to see those questions go into the Q&A piece so that we can see that they should be addressed during the programming. But we will try our best to address all of those. And for future programs, we do offer a couple of ways that you can submit questions ahead of time. This is great because it gives our panelists a chance to explore a bit further. So feel free to take advantage of that in the future. All right, up next, let's see, and we can continue one more slide. I just wanted to talk a little bit about who we have with us today. We have Housaye Law and Associates. Angela Housaye is the CEO and founder, and she's their managing attorney. They are a wonderful chamber member and asked for a way to get more involved this year to benefit the small business community and our community as a whole. And I was thrilled to hear that when I was thinking about planning this session. So we're really grateful to have them with us today. We also have Kellen Stevens, a transactional attorney, Christina Romero, an associate attorney, Lindsay Meyer, an associate attorney, and Jacqueline Menendez, a law clerk. And please, my apologies if I got any of those things wrong, but I would love to welcome Angela to tell us a little bit about the firm, and then we'll hear some background from our panelists. Angela, we'll just have you unmute. Perfect.
Okay, sorry about that. Hi, everybody. Good morning, and thank you for having us. We're really happy to be here. As Amelia said, I'm the founder and CEO and managing attorney at Housaye Associates, which is known as DLHA Law Group, and we're a full-service business law firm. We have offices in San Francisco and the East Bay and Los Angeles. And when this pandemic hit, we found that we were pretty surprised and that we were thrown into a bit of a whirlwind with our firm, which we quickly assembled a team of our experienced attorneys to comprise the task force that you see here, because we knew that our clients would be facing the same sort of business questions and issues and problems and hurdles that we were. So we've been gathering information. Each of the attorneys that Amelia mentioned specializes in a different area on our COVID task force, and they'll each be presenting their specific specialized area. So the first person that's going to speak will be Lindsay Meyer, and she's our employment law specialist, and she'll be speaking about employee terminations, layoffs, and furloughs, And again, these topics cover a host of different areas, mainly from the business side of things, from the employer side. And we have assembled our focus areas based on our clients' areas of problems or issues that they've been facing. So when we get to the question and answer session, if there's some specific area that you'd like us to elaborate on, we're happy to do that. Next will be Christina Romero. She's our compliance attorney, and she'll be speaking about short-term disability and eligibility for disability insurance and unemployment insurance. After that, we have Jackie Menendez, and she also works on the compliance side. She also handles litigation support. She'll be speaking about paid sick leave and paid family medical leave, as well as a really important area that a lot of our businesses are facing right now, and that is how to handle employee health and safety as your businesses and businesses in your community start to reopen, which is a really, really timely question. And last, we have Kellen Stevens, and he's our compliance attorney, and he'll be and transactional attorney. He's a senior transactional attorney with a background in business and finance and banking. So he'll be talking about economic relief for businesses, and specifically the CARES Act and the Paycheck Protection Program, other kinds of economic relief, including that California IBANK, and how to control costs. And under that purview, he'll be speaking about things like rent, mortgage and loan agreements, and things like that. Because of our time frame, we're keeping our topics fairly broad. But again, on the question and answer session, if you'd like to ask specific questions, we're more than happy to entertain those. So with that, I'd like to introduce Lindsay Meyer. And again, she's the employment attorney.
Good morning, everyone. It's so nice to be here with you. Thank you for having us. It's a pleasure. As Angela just said, I'm going to be discussing with you employee terminations, layoffs, and furloughs. We have been getting so many questions from our employer clients who are now unfortunately facing that very difficult question given the current pandemic. Do we need to reduce, are we going to have to reduce our workforce? And how do we go about doing that? And many employers are asking, what's the difference between a layoff and a furlough? Should I be furloughing instead of laying them off? A furlough generally is treated very similar to a layoff or termination under the law. However, a furlough tends to be used when an employer is seeking to retain that employee and have them come back, and usually a relatively short period of time. Maybe the furlough will be for a month or 2 months, but the end goal is that that employer wants the employee to come back. Now, with a furlough, many employers, especially large employers, are opting to maintain the employees' benefits for them, including health coverage. And so if an employer is going to be doing the furlough, that's something that the employer needs to look into, and also determine whether or not they're going to have their employees continue to independently make their typical employee contribution to their benefits, or if the employer is going to cover that for them. Now, if the employer opts not to provide the health insurance coverage during the furlough period, then the COBRA notification requirements go into effect just as if that employee had been laid off or terminated. Regarding sick pay, we're going to discuss that further into our presentation, so I won't go into it into detail. But if an employee is not otherwise entitled under the law to sick pay at the time of a furlough or layoff, the employer does not have to pay out any sick pay to that employee. Again, there could be circumstances that would permit that employee to receive sick pay, and we'll discuss those later. Vacation pay, that's another one that gets a little confusing when you're deciding whether to furlough or to lay off. Now, if you lay off or terminate an employee, all wages earned under California law, which include any accrued or unused PTO or vacation time, must be paid out immediately. However, if a furlough is a very short-term furlough, which does not exceed 10 days, and the employer provides a return to work date for that employee, then that furlough is not considered under the law as a termination, and the employer is not required to pay out any accrued and unused vacation or PTO on the books. But if the furlough exceeds 10 days, which most employers are having to furlough longer than a typical pay period or 2 weeks, then the vacation pay or PTO needs to be paid out at the time the furlough goes into effect. So moving on, other questions we've been receiving from employers, they are trying to find alternatives, to, obviously, to doing the furlough or the layoff. They'd like to maintain their workforce if they can. So one alternative would be reducing an employee's hours. Employers ask, can we do that? Are we allowed to do that? Absolutely, you can reduce the employee's hours. If you do this, just be aware that the employees are allowed to apply for and receive unemployment benefits on a prorated basis based on that reduction in the hours. Other questions that come up are, can we reduce the employee's pay? Again, yes, you can. You can reduce an hourly employee's pay or a salaried employee's salary, but just be cautious that you aren't violating, or if there's a employee's salary because they're have exempt status, you want to make sure the reduction in salary doesn't take them out of that status. So you would want to consult an attorney to make sure you're preserving their exempt status. But yes, you can reduce hours, you can reduce pay, and we do recommend that you provide employees advance written notice as soon as practical, as soon as possible. When that happens, employees obviously will ask you, when can I expect my pay to go back up to what it used to be? How long is this going to be? We recommend that you do not make any promises to avoid any type of contractual obligations between you and the employees. Just let them know you're doing your best and this is what is happening given the current circumstances, but don't make any promises. And lastly, for employers who are having to do mass layoffs, the California WARN Act, which is short for the Worker Adjustment and Retraining Notification Act, that is still in effect. That's a regulation, for those of you who are not aware of it, that requires employers to provide at least 60 days notice before a mass layoff of 50 or more employees in a 30-day period. The WARN Act requirement only applies to California employers who have employed at least 75 employees in the past 12 months. And for that count, that includes part-time and full-time employees. It's not just 75 full-time employees. We get that question a lot. However, given the current pandemic, the Labor Commissioner's Office has issued an executive order that has suspended the strict 60 days advance notice of the mass layoff to employees. So now the employers, they're still required to follow all the other requirements of the WARN Act, but they must just give as much notice as is practicable. And so they're not requiring to do that 60-day advance notice. And that concludes my piece of the presentation regarding furloughs and layoffs. Again, that was just a broad overview. So if you have any more specific questions about any of those pieces, please send in your questions and we'll try to get to them during this presentation. And now I'm going to pass over to Christina Romero, and she will be discussing short-term disability and unemployment insurance. Thank you.
Hello, good morning, everybody. Thank you, Lindsay. My name is Christina Romero, and I'm going to be doing a short overview of both disability benefits and unemployment insurance. So let me begin with disability. Disability insurance provides short-term benefits to those eligible workers who are suffering from either full or partial wage losses due to non-work-related injuries, illnesses, or pregnancies. Now the eligibility has expanded to include those who are suffering from or been exposed to COVID-19. So in order to apply for these benefits, you would do so online and file a claim with the EDD. And you would also have to provide supporting documentation, medical certification from a certified medical health practitioner who can attest to your disability. If you are eligible to receive these short-term benefits, the benefits are roughly between 60 and 70% of your wages, and it's just dependent on your income, so it's specific to each individual. The benefits will be paid either from the date that your medical provider certifies your disability, or when other available benefits that are being used run up, either of which comes first within a 52-week period. Lastly, Governor Newsom, with his executive order that was passed last month in March, he did waive the 1-week period, waiting period for both the receiving the disability insurance as well as unemployment insurance. So with that, I will start going into the unemployment insurance. So if a worker has been laid off, either permanently or temporarily, they may be eligible for unemployment benefits. So I'm going to go through different options or avenues, and one's at the state level, and then the remaining 3 will be a federal expansion of state level benefits. And so starting with the state benefits, to confirm, all disability insurance is administered by the state. And so traditional California disability insurance, unemployment insurance applies for a 26 weeks period, and the benefits range between $40 to $450 a week. Again, you can file your claim online with the California EDD, and the government did just recently issue a statement because there has been a backlog. There's just been an overwhelming amount of claims for unemployment insurance. And so there is a delay in people actually receiving those benefits. But the government did recently address this issue and acknowledge that they will backdate the benefits claims to the date that you were let go, through no fault of your own, rather than the date you are either submit your application or you are improved. So unfortunately, there is a waiting period, but you will receive back pay for that. So that's the first state general avenue, traditional employment benefits. Now moving on to the federal expansion, which was passed through the CARES Act. The Part 1 expansion of that is it authorizes the states to extend disability insurance for additional weeks. So right now, California is at 26 weeks. This can be expanded up to 39 weeks. No state has actually passed this yet, but I'm sure as we start reaching that 26-week benchmark, California will apply the additional weeks up to the 39-week benefits. So moving on to the second part of the federal CARES package, is the Pandemic Unemployment Assistance Program. So this was created as a brand new program, and it was created for those who are who work in the gig economy. So this would include business owners, self-employed individuals, independent contractors, those who wouldn't be eligible for regular state unemployment benefits. So if you fall into one of those classifications, you can file a claim online with the EDD. However, California is still awaiting guidance on how to actually roll out this program. So if you think you are eligible for this program, monitor the website, the EDD's website, for daily updates. I checked today, there's still no rollout of the program, but just keep monitoring that, and they'll provide ways, the method and manner in which to apply for those. But when you do file the claim, you must certify your proof of employment, that you're self-employed, and in terms of the benefits received, this will be based off of previous income, and so you'll need to submit certain documentation disclosing your past income. So these benefits are eligible for 39 weeks. Starting with the weeks of unemployment from February 2nd of this year through the end of this year, December 31st. But this just depends on when you became directly impacted by the pandemic. So moving on to the last part 3 of the federal CARES package, unemployment insurance expansion, is the Pandemic Unemployment Compensation program, so the FPUC. So under the FPUC, the states will administer an additional $600 federally funded benefits on top of any benefits already received. So this would include both traditional unemployment insurance and pandemic unemployment assistance. And so, and the claims only apply between March 29th of this year through July 31st. So if you have claims between those dates, you'll be eligible for the additional $600. The same as with the Pandemic Unemployment Assistance Program, the FPUC has still been yet to roll out. There was word that it was supposed to roll out this week. Again, I checked this morning. I didn't see anything, but it's Wednesday, so we still have a few days left, and I have hope that that will be rolled out soon. If you have any questions, that wraps up my both the disability and unemployment insurance. If you have any questions, please feel free to submit your question in the Q&A or reach out to us directly. So now I'm going to move on to my colleague, Jacqueline Menendez. She's going to cover paid sick leave, paid family medical leave, as well as employee health and safety. Thank you.
Thanks, Christina. Hi, everyone. As Christina mentioned, I will be covering paid sick leave, family leave, and employee health and safety. Now, first, regarding paid sick leave, Congress passed the Families First Act, which provides for expanded paid sick leave and family leave obligations. This law went into effect on April 1st, and it's effective until December 31st of 2020. Now, employers with fewer than 500 employees must provide up to 2 weeks of paid sick leave at full pay when the employee is unable to work for reasons related to COVID-19. This includes full-time and part-time employees, but there is an exception for business hardship. And also, I must note that employers must provide notice of these new requirements to current employees, either by posting the notice in a place in the office that is visible to all employees, or by sending an email with the notice to current employees. And the notice has to be posted by April 1st of 2020. The Department of Labor has this notice requirement and the notice itself on their website, so you can retrieve it there. Now, in regards to family leave, the biggest change in the law is that now an employee who is caring for a child whose school is closed or where childcare is unavailable can qualify for family leave and receive up to 2 weeks of paid leave at 2/3 of the employee's rate of pay. And in addition, if an employee has been employed for at least 30 days, then they may qualify for up to an additional 10 weeks of paid leave. However, if the employee is able to still work from home, then they would not qualify for family leave. These issues are really fact-specific, and it's best to talk to a lawyer about the specific circumstances individually. Many of the issues hinge on the classification of an employee, so that's why we recommend that you speak to a lawyer directly. And in many respects, the law is still very unclear, and there are rumors that there will be a legislative amendment to clarify some portions of the law. And we here at DLHA are monitoring the changes very closely. Many of you may also now have employees that are working from home, but when employees do come back to work and when they physically enter the workplace again, then employers can ask employees if they have symptoms associated with COVID-19 or if they have been tested for COVID-19, because the WHO has now declared this a pandemic. However, these questions have to be limited in scope. So for example, an employer can ask an employee if they have a cough or a sore throat, fever or chills, the symptoms that are associated with COVID-19. But they must keep any information that they retrieve about the employee's health status as a confidential medical record and keep it separate from the personnel file. And it has to be in accordance with ADA requirements. Now, if an employee is working from home and they're not physically interacting with other employees, then the employer is not allowed to ask these types of questions. Now, employees themselves may not be sick, but they may be caring for a family member who has the coronavirus. employers cannot ask whether their family members have the virus, but they can ask if the employee has been in contact with anyone who has had the virus. It is better to ask this as a general question because it is against the law to ask medical questions about an employee's family members. So that's it for me now. That's the end of my segment. So I'll hand it over to Kellen Stevens, who will be discussing economic relief and controlling costs.
Okay, hello everyone. I'm just trying to work on my video feed here, and I think that I can start it right now. There we go. All right. Hi everyone. How are you doing? So I think what Jackie mentioned, and I just want to kind of reiterate this with what Jackie mentioned and Christina mentioned, is that a lot of the guidance that we've received from the government is pretty fluid. A lot of their responses are fast moving and they're changing kind of daily. So we do update our clients and we try to maintain updates with respect to all these different laws as they're enacted. But understandably, these laws were enacted quickly to address things immediately, and that there's always like kinks that they have to work out. So with respect to that, the first thing I'm probably going to talk about is what you know as the Paycheck Protection Program. This is a huge bill for small businesses that provides up to $10 million or 2.5 times payroll. You can use it for payroll, for rent, for utilities, for mortgage interest. The thing about it, though, is that it's first come, first serve, and that I believe there's been over 1 million applications, and about $250 billion out of the $300 billion has been approved. Now they're looking to a second round of funding, but that hasn't been approved yet, and so we're not going to necessarily rely on that. With the funding itself, you might also know that the biggest part about this program is that there's a forgiveness aspect. They forgive up to 75% of the amount that's used on payroll and 25% on any other cost for the 8-week period that follows disbursement. So if you submit an application, the bank has 10 days to fund it after approval. Then there's a disbursement and it covers costs for 8 weeks. If your lender right now is not accepting applications, the SBA website lists lenders that are. And we also just advise you to call lenders, contact multiple ones, submit multiple applications, just because it's first come, first serve, and once the money's gone, it's gone. There's also the economic disaster loans, and California has a similar program called the disaster relief loans. These are in smaller increments with less favorable terms and no forgiveness, but they're still pretty accessible lines of credit that have compared to other, commercial rates have favorable rates and favorable terms. And also in San Francisco itself, there's a Hardship Emergency Loan Program, which I believe provides up to $50,000. And I think that it's a zero interest. So it's kind of like a grant after. And I know that was released recently. So that's something else that you could look into if you're based out of San Francisco. And so I think the next thing is that what we've had a lot of clients talk to us about is getting access to capital and the loan programs that have been available. And then 2 is just what do we do as business owners with some of the issues that have cropped up. Primarily those issues are, what do we do with our commercial leases? And what do we do with our current loans that we have? And so for both of these situations, the idea is that you got to communicate early and you have to communicate often. You should be talking with your lenders or you should be talking with your landlords in order to come to terms or workouts with them. Now, with respect to leases, California has temporarily prevented courts from processing evictions or judicial foreclosures. Governor Gavin Newsom had issued executive orders that allowed local governments to put moratoriums on commercial tenants' evictions. Mayor London Breed enacted a moratorium on commercial and residential evictions. So those are outstanding right now. What you want to do is if you're a tenant, you want to consider extensions or you want to consider modifications. If you're a landlord, you have to be cognizant of the moratoriums on commercial and residential evictions, and also know that landlords are encouraged to work with tenants by financial authorities. So in both cases, the parties should be working together to figure out if they can modify the terms or extend the leases themselves. For borrowers, what we're really concerned about here is you can enter into modifications, you can enter into extensions, which are another form of modifications, but you have to be very mindful of the financial covenants. And if you have a credit facility and you're drawing money from it, that on every time you do, usually when there's a draw, there's a rep and warranty. And you want to make sure that during those covenants, you want to make sure that while you're drawing money, that you're not engaging in, or that you're not violating in the financial covenants or the reps and warranties. And I think lastly, we have had some questions about contract performance, specifically questions about force majeure. I can tell you that force majeure, if you don't know that, that's like an act of God. That is usually, it used to be pretty boilerplate language. Now what we've seen is this very specific between the parties and what they define. It could include pandemics, but it just as well might not. And I think that, with all of these instances, the best thing you can do is look at your contract, look at your lease, see if it's included or not. And then also what we've seen is even where it is included, it expressly provides that the tenant's obligation to pay rent is not excused or delayed, but it can delay the landlord's obligation to provide certain services. So it's important to be mindful of that as well. And I think that that's it. So I'm just going to end here now so we can move to the Q&A. I know that there was at least 10 or 12 questions that have come through, and I think that we want to be able to get to everyone as much as possible during the time allotted. So I'm going to end our slideshow and hand it back to, I believe, Amelia.
Awesome. Thank you, Kellen.
You're welcome. Yeah.
Perfect. So thank you, everybody, for those great presentations. We can go ahead and welcome all of our panelists back onto camera. And we had a great variety of questions that came in ahead of time. So we're going to address several of those first, and then go through some of these great questions we've seen come in through our Q&A tool. As a reminder, just do use that Q&A tool rather than the chat. It allows us to make sure we see those and get them into our queue. We're going to do our best to cover as many of these questions as we can today. However, as a reminder, the De La Housaye firm has agreed to answer some of these questions in an after webinar FAQ, which we will get out to everybody as soon as possible. And also just remember that we're taking the perspective today from you as a small business employer, primarily, though we will try to address some individual questions if they come in as well. So let's go ahead and take a look at some of these employment questions that I saw come in ahead of time, team, if that's okay. So I know we addressed furloughing and laying off employees. I had the question that came in, if there is a major difference between furloughing and laying off employees. And what I understood from Lindsay is that the major difference is about benefits during that process and the intention to bring employees back on. Were there any other major differences that folks should be aware of?
Regarding the furloughs, generally, I think the furlough is just a big concern. I see questions queuing up about the vacation pay. And it's really, the difference is how long is the duration going to be? And I can get more specific into the questions, but when you're going to do a furlough, a layoff is, you're severing the employment relationship, where a furlough is generally, the intent is we'd like to bring that employee back. So we want to maintain the benefits usually. But if you don't, then the COBRA notifications are still required. And then if it's going to be a short term within like a pay period furlough, then you do not have to pay out all wages earned and accrued, which would include the vacation and PTO upon the commencement of the furlough. But otherwise, if you're going to be following the guidance provided by the Labor Commissioner's Office and the opinion letters, like strictly to be on the safe side, then yes, you would pay it out if it went past that period of time.
Got it. Thank you. And just regarding termination, I have this question. Can I be sued for wrongful termination if I can't afford my employees anymore? Is there anything people need to be aware of there?
I could take that one. Unfortunately, unless you have an employee sign a some kind of severance agreement and release of any and all claims against you at the time that you terminate them, they can come back and bring any claim against you at any time. But, generally speaking, as long as you've taken precautions and you're following the laws, to the best of your ability, that will prevent anyone from probably even wanting to initiate a claim against you. But yes, I mean, if you do terminate someone, of course they may try to come back, but as long as you're following the laws, you'll be able to defend the claim, and more likely than not, they won't come after you for anything, because if they go seek the advice of legal counsel, the attorney will tell them, hey, that employer, they were following the laws, they didn't do anything wrong, you have no case.
Great, thank you. And so how about, I know we addressed a little bit about being able to find out if your employees or potentially delivery people, this is a specific question, are sick once we start getting back to work, or even for those who are essential businesses that are operating right now. So this question is, I need to know if my restaurant employees and delivery people are sick. Can I take their temperature when they come in? I know we had this specific question about asking about symptoms, and that was addressed already. I'm actually thinking with this one about delivery people, if they're not your employee, is there anything that folks should be aware of there? I don't know if it's something we can address right now.
If I could, I'm gonna have Jackie Menendez respond to that.
Yeah, I can answer that. So the EEOC has issued guidance saying that employers can ask their employees to take their temperature. And they can even bar the employee from coming in if they refuse to take their temperature or answer questions related to symptoms. However, the employer should be very careful, because there is limited case law on this, because it's a pandemic that we haven't encountered before. So it's unclear how the courts will actually rule. So it's best to talk to a lawyer and really think through how you will approach your employees when it comes to asking them those types of questions.
And I think that was the question about a delivery person and independent, so someone just coming into the company. Lindsay, do you want to take that one?
Sure. As someone that that has no legal obligation, you have no legal relationship with or contractual relationship with, someone just delivering items to you, I'd probably just request the no contact delivery. I don't know, you could contact their employer and ask what precautions they're taking with their delivery people and what their policies are, because they may have something set up now. I know many of these delivery services, what they're doing is they're having no contact drop-offs just to completely prevent that issue. And I am aware in other states, not in California, they are actually taking employees' temperatures who are working in the warehouses where they're doing deliveries. But again, I think if you're concerned about a delivery person, you should reach out to that company and see kind of what their policies are and what they're doing to ensure that the people who are actually delivering whatever the product may be are, healthy, well, and taking the precautions to keep, any germs from spreading when they make those deliveries. Does that answer the question?
I think so. That makes a lot of sense. It's, using
Okay.
more discretion.
Yeah.
So we have quite a few questions related to leases and contracts that have come in as well. I think we've had a couple in the queue as well. So I'll ask one overarching question, and then let's jump to the Q&A session that we have on screen, because I think some of those topics answer our other questions that have come in. So I have one statement here. I would love to hear what our legal options are with respect to our leases. Is it possible to, it's impossible to pay full rent right now, yet we're still legally obligated to do so. With operations likely to be impacted for quite some time, can we argue that the world we live in is just so different from when we signed the leases and that they should no longer apply? And this questioner does note wishful thinking. So is there any guidance that we can give folks about negotiating and talking about their leases a little bit further?
So I'll give that to Kellen. Kellen, I think you're on mute.
I was, thank you very much. So first of all, I think that I had mentioned this in my presentation, but the most important thing to do is to communicate with your landlords. Primarily the reason that they need you to pay your lease is because they owe money on the mortgage, but financial authorities have released like an interagency statement like a week ago that allowed lenders to modify like the mortgages or loans without adverse consequences for the borrowers, for the banks that lend to them, which has a downstream effect on the eventual lessees themselves. And also there is the commercial moratoriums like in San Francisco. Again, these don't mean that you don't owe the rent. They just mean there's a moratorium on paying for it. Unfortunately, the mayor's order that she issued in late March didn't specify if late fees were included in that. So again, it's kind of like working with your landlord. And the important thing, I think, when you work with them is if you're having trouble paying rent, you communicate in writing that you're having trouble paying rent or unable to pay rent, and that you state that you are suffering economic hardship because of COVID-19. And that's the reason why you can't pay rent. And that's what you put in writing. And that allows you to take advantage of the moratoriums that exist now. And then you can get into the discussions about modifying the lease, and how that could work, whether it would be, so you could, for instance, request an abatement, which would just reduce the amount that you owe. You could request a deferral, which is what a moratorium is. You could also talk about, the landlords themselves have obligations to keep the premises up and running right now. That costs money for them to do that. So you could come to an agreement with them and say, hey, look, perhaps what we could do is if you allow me to defer or abate or extend, then maybe I will agree to release you of your obligation to keep the premises open, which reduce your operating expenses without breaching obligations to the tenants during the shelter in place. So that's why kind of like that communication is so vital between the landlord and the commercial tenants. Overall, this is incredibly, unprecedented event. It's difficult for everyone. I talked a little bit about force majeure. That usually doesn't apply in these instances for renting. There's other kind of ideas of contractual relief. They're called like frustration of purpose or impossibility or impracticability, but we don't really see those being applied now. And they're kind of like, they are a legal argument that you would have to establish. And of course, a particular business, it might make sense for a particular business, but each one of those are, unfortunately, it's a very like fact specific inquiry. And so the best general advice we can give is talk to your landlord, specify in writing that you're enduring financial hardship and can't pay rent because of COVID-19 and the impact on your business, and look to what sort of modifications are allowable or that they'll work with, and know that the financial authorities and their lenders have been told to work with them to help them on their payments as well.
Great, thank you, Kellen. I think that was covered a couple of the questions that came into that area. So now we have several questions in the Q&A queue. Angela, would you like to address some of those and divvy them out to the team?
Sure, I'd be happy to. I think the first one was sent in at 11:05. It says, as the employer, can we force our employees to use their PTO? We are running out of work, but have some employees with 4 to 5 weeks of PTO. Can we make them use that? And I'm going to have Lindsay answer that question.
All right, let me unmute myself there. So that area of the law is a little gray. There's some differing authority, but because there is authority that says employees cannot be forced to use their vacation time. However, there is guidance from the, I'm sorry here, just looking at something to make sure I get it right. There is guidance from the Labor Commissioner's office that an employer can require employees to use accrued vacation during a shutdown, or just as long as the employer gives reasonable advance notice, which they're deeming to be no less than 90 days. So if you can give them 90 days advance notice that you would like them to use their vacation, yes. Otherwise, I would not force them to. They can elect to, but if you are able to give the 90 days notice before, then I think you should be okay.
Great. The next question came in at 11:06. It says that I'm concerned about whether UI, which is unemployment insurance, will be available to independent contractors as enabled in the CARE legislation section, PUA, pandemic unemployment insurance. Applied to EDD, apparently was rejected. Their answer was that they're waiting to hear from the Department of Labor. This has been their answer since March 27th. If this, okay, no, that's help. That's a good question because I think a lot of people are going through that. I'm going to let Christina Romero address it as best she can.
Hi, thank you. Yes, so in terms of the pandemic unemployment assistance, this program, like I mentioned, it hasn't been rolled out yet. California is awaiting direction and guidance from the U.S. Department of Labor on how to actually initiate that and how to have a process for that in place. So there's actually no application currently available for that. Like I mentioned before, you know, all you can do is just keep checking the website daily to see if it's been updated and to see if they do have updated a section for you to file the claim.
Thank you. Sorry, my mute button wasn't responding. The next question came in at 11:07. Do you expect to see a large increase in bankruptcy filings after this pandemic, especially in the small business community? It's hard to say what will happen. I know that our firm's been working a lot with different businesses and there are different vendors, business owners, building owners, things like that to see what they can work out. And I think by and large, everybody's trying to be forgiving and work out agreements and extensions for payments and things. So my hope is that we won't, but you know, the future's difficult to foresee. And I think that unfortunately there will probably be a lot that happens in the wake of this pandemic where businesses just aren't able to survive, and how that dissolution or bankruptcy or unraveling or how businesses tend to handle the whether or not they close, we'll just have to see what happens. I do know that the government is working on different, as you know, probably bills to try to work out resolution without seeing businesses go under. So I think this climate is a little bit different than one that you would see in a typical situation where a business runs out of money and just can't continue. I think there will be options for them other than bankruptcy, and we're just going to have to wait and see what happens. The next question that I believe came in at 11:08 is, let's see, it just dropped down. Sorry about that. I just want to get the question correct. Do you have any details about the EDD Workshare program? I submitted an application for our company without completely understanding how it works and how soon it can work. My salaried employees were classified to hourly workers starting this week at the beginning of the pay period. We're running out of work. Some employees have no or very little work to do. So I'm going to give that question to Christina Romero. I do want to just insert here a little caveat that every business is very nuanced, every set of facts, and every business has a history. And so what we're giving you is our best opinions based on the information we have. It's not legal advice that you can just rely on by and large, because it's difficult for us to do this in a snapshot, if that makes sense. So we recommend that everybody consult their business attorney. If you don't have a business attorney, you're welcome to email us separately. We've left our email at the bottom. But to have comprehensive legal advice that you can rely on, it's best to have an attorney look over your specific history, facts, scenario, the way your company is set up, your compliance records and everything. So with that caveat, with that legalese, I'll have Christina respond.
Thank you, Angela. Yes, of course, this is a employer-specific question. That being said, the work sharing plan should become effective the Sunday before the date that you contacted the EDD. And so as far as timing, it should be that Sunday before is when it becomes effective. But in terms of the rest of the question, that would be, it's a specific employer question that we would need additional facts for.
The next question came in at 11:13. If furlough exceeds 10 days, vacational or vacation personnel time needs to be paid out. I'm sorry, personal time doesn't need to be paid out. Our HR source did not mention this and have already furloughed some employees. Are we in violation? Please send source for this information. I think Lindsay alluded to this a little bit previously.
If you go to Labor Commissioner's website, and they have what are called opinion letters, DLSE opinion letters, and the division policy has long been, and this is quoted, that a shutdown does not, as long as a shutdown does not exceed 10 days and there is a definite date given for a return to work, the employee is not considered terminated. And later there was another opinion letter that came out that gave a little bit more guidance. And it says, if an employee is laid off without a specific return to work date within the normal pay period, so that to me is slightly different than the 10 days. So that's already a little bit conflicting there. But it says, if an employee is laid off without a specific return to work date within the normal pay period, the wages earned to and including the layoff date are due and payable in accordance with Labor Code Section 201. So that includes any wages accrued and earned, which is vacation time or PTO time. Doesn't include sick time, includes vacation and PTO. Sick leave is different.
Thank you. Thank you, Lindsay. I also want to add that we work pretty closely with HR companies, and HR companies are wonderful resources for businesses. They help them avoid the very high cost of attorney's fees when they don't need to pay for that level of service. But it's a lot of times HR companies will come to us for legal advice on questions that are on the line or that they don't know the answers to. So if you're not sure, you should definitely contact an attorney.
And I want to make one more comment, if I can, Angela, on that. So if you are, as the employer, and I always, in California especially, because it's so deferential to employees, and it's really difficult to be an employer, as you all know, in California. If you are strictly following that DLSE guidance, employers would need to pay all final wages if they cannot specify a date within that normal pay period for the employee to return to work. So it's really not clear at this point how the courts would whether or not the courts would absolutely strictly follow this guidance, or if they would, given these extraordinary circumstances, if they would be forgiving of it. So if you're going to follow it strictly, then yes, you would pay them out if the furlough exceeds that one pay period time frame. But again, it's hard to say what's going to happen, and I would not be surprised if there was some kind of exceptions made during this pandemic period.
Great. The next question came in at 11:17 for a furlough. Do you need to fill out any paperwork? My business employs hourly workers and their hours have been reduced to 0 as we are not open. And I'll just address this generally with our firm. We always recommend that with any change or modification to your employees, even if it's one employee, that you document it. And a lot of times we will ghostwrite the policy if you're doing more than one layoff or furlough, or we'll ghostwrite the individual record of a furlough or a layoff for the employers, because you don't want any misunderstandings. One of those could be, you could be putting an employee on furlough, not have a return to work date, say, we look forward to seeing you soon. And if you don't have anything in writing, the employee may assume that that is a return to work date, or hope to see you in the spring or something. And if you have a return to work date, that initiates a whole other set of compliance regulations. So with that caveat, Lindsay, did you have anything to add to that question?
No, other than just the COBRA. If they have essentially been furloughed or laid off without a return to work date, you want to make sure any COBRA notifications are being sent out. If they are furloughed, they are eligible for the unemployment insurance benefits. So if that paperwork comes in, you want to make sure that's filled out on behalf of the employees so they can start receiving their benefits right away. If there's any more specific question about paperwork, go ahead and send that in, because I think Angela otherwise covered it.
Okay. The next question is 11:18. We temporarily furloughed 10 to 15 employees from March 16 to 31st with a return to work date of April 1. Since greater than 10 days, I should have paid them all accrued vacation, ? Lindsay?
Okay, so in this situation, I think given the clarification that the DLSC has provided in one of its opinion letters, where it says if an employee is laid off without a specific return to work date within the normal pay period. So right there, that's I think you have that time frame sounds like a normal pay period to me without knowing any more additional facts about your business or what happened. But if you and you've given them a specific return to work date, so I think you should be okay and you should be in compliance. And I don't see that those had to be paid out in this specific scenario because it was literally about a 2-week furlough with a specific return to work date. So I do not believe they would be deemed terminated and in violation, or nor you be in violation of Labor Code Section 201.
Okay, and the next is a follow-up question about vacation payout. Can employee elect not to receive payout, meaning I guess vacation, as they wish to preserve vacation hours for when they come back to work?
And since it's from the same person who just asked this question, in that specific scenario where you're only doing that very limited furlough that's complying with the advice, the guidance given by the Labor Commissioner's Office, yes, that's fine. They can preserve their vacation time. If they elect to use it, you can permit them to use it as well. But yes, they can preserve it in that scenario.
Okay,
Hey,
great.
Angela.
Yeah.
So we are, just everyone, for a heads up, we're about to hit our hard stop. I know that there's several more questions we haven't gotten to. There's also quite a few questions about EIDL loans, SBA programs, and the Paycheck Protection Program. We'll be addressing those afterwards in writing between this group and also my contacts at SBA. So you can look out for those. They have been seen and noted. Can I just ask this one last question I saw in the queue? It's something I hadn't seen. If the city has ordered my employees to shelter in place and my business is not essential, would it not be the city that set my employees home? And I guess insinuating I didn't lay off my employees, the city laid off my employees. What would you say to that question there?
Well, I can give a general answer, and then Lindsay can follow up with some specifics, but that's generally happening to most businesses. The city has, and your regions really, I mean, in the East Bay, it's the County Board of Supervisors, have ordered a shelter in place. And as employers, if you don't fall under one of the essential businesses as those are defined, you really have no choice, and you probably want to keep your employees safe. So there's a couple scenarios. One is you can try to figure out how to set up remote access. If your business isn't one that's conducive to remote access, then yes, and that's why there's all these federal programs that allow these types of unemployment. If you determine that you have to lay them off, you have to furlough them, that's why the government's come out with all these different types of programs. And that's why there's this huge influx on getting the grants and loans to see, and that's also why the PPP is geared specifically towards keeping your employees employed. But Lindsay, did you have anything to add to that one?
Just along those same lines, if the employees are, I don't have the question right in front of me, I'm sorry, but if the employees are required to shelter in place, that is one of the eligibility markers for, I believe, the sick leave under the new federal act, and also just in general. So it's listed on, if you can go ahead and look that up. I think Jack, you could comment on that if you want, but
yeah, it is listed, yeah, as one of the requirements for shelter in place. And then also they would be able to qualify then for paid sick leave or family medical leave.
Right.
Thank you for addressing that question. And again, folks, we will be taking a closer look at some of these written questions that came in and be circling back with all of our attendees today. At that point, I'm going to go ahead and close this out. I've got a couple pieces of information to share, but I want to say thank you so much to our amazing panelists from Housaye Law. It is not every day that you get to sit down in a room with 5 attorneys, unless maybe you're in a lot of trouble. I said that earlier, so we don't want that to happen. But thank you so much for sharing your time and knowledge with us, and we'll circle back with all of our attendees in a bit. So just quickly, you can email info@delahousaye.law If you want to get in contact with them or ask more questions, I will be sure to send out this information afterwards. Becca at bbevents.biz can be contacted if you have questions about our upcoming webinars as part of the Small Business Weekly session. And then our next program is going to be our Ask the Chamber Town Hall Policy Discussion, which is this Friday, April 17th, 10 a.m. to 10:30 a.m. Pacific Standard Time. That's free to join, and we will have our policy team, including myself, Jay Chang, our policy director, and Emily Abraham, our policy manager, addressing policy-related questions for you. And those can be anything related to new laws that are coming through the books that are impacting your business, any specific questions you have pertaining to your business and operations during COVID-19. So do feel free to join us. You can register by visiting sfchamber.com and then going to our calendar, which is under our events tab. You'll see it there this Friday. But thank you again, everyone, for joining us, and thank you to Bank of America for sponsoring this program. Have a wonderful day, everybody.